Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss an important principle of natural justice. The second principle of natural justice, that is adi alteram partem. That means whatever be the allegation, you have to give a chance to the other party for explaining his grievance. You have to hear the other side. If it is not there, so the complete justice could not be said to have been done. That is what happened in the case of District Bar Association, represented by or through its General Secretary Amethi, District Bar Association Amethi versus State of UP and 6 others, in Public Interest Litigation number 828 by 2022, decided on 30th November 2022 by UP means Allahabad High Court, which observed that the act of demolishing the houses of the advocate Mr. Umesh Kumar Sharma and others in undue haste is highly disapproved. So they have damaged or destroyed the houses of course, no doubt, as per legal procedure only, they have demolished the houses, but without giving notice to the other party or without giving a chance to the other party to represent. So the act is done in haste, which is not at all accepted by the Honorable High Court of Allahabad. And moreover, the district administration, that is Amethi administration, they have filed a number of cases. For example, they have filed an FIR under section in crime number 432 by 222 under section 2 and 3 of the PDPP Act, that is Prevention of Damage to Public Property Act 1984 of Gani Gunj PS. Of course, it is in Amethi district, Amethi, Raebareli. Previously, they were famous because once Indira Gandhi and Sonia Gandhi, they used to report those constituencies. Nowadays, we are not having much knowledge about the same. Right. Coming to the facts of the case, actually, Allahabad High Court rapped, R-A-P-P-E-D, or rippled into pieces the Amethi district administration for the act of filing number of FIRs and also demolishing the buildings owned by the members of the Bar Association without serving any notice, without due process of law, without following the principles of natural justice. Right? So, two judges bench, Justice Devendra Kumar Upadhyaya and Samadh Srivastava. So, they held like that. Okay. Now, the facts of the case are that Amethi District Court or Amethi lawyers, they are agitating for the institution or for the functioning of a civil court, especially in Amethi. Otherwise, they have to go to the nearby Raebareli or Sultanpur, some other constituencies to get justice in civil cases. So this is their demand. They have been actually pestering upon the district authorities. They have been sending representations. Actually, they are supposed to meet the district collector. Actually, the meeting was about to be fixed, but the district collector said he didn't find time, he has no time. So, agreed by this, they started sending a lot of representations to the higher authorities, and they are actually boycotted the court only for what? For the institution of the, or they for the functioning of the civil court in Amethi. So, when the district magistrate refused to give appointment to them or refused to hold a meeting with them, so they are disgusted and they have propagated that how can the collector not find time to meet the advocates. So this irked the district administration. They wanted to teach the advocates a lesson. They have caught one point. So here the secretary of the Bar Association, Mr. Umesh Kumar Mishra, so he was given a land in exchange of the previous land, maybe in a very old case. Actually, the property in which presently Mr. Misro was residing and which was demolished. It was given in exchange for his land by means of an order dated 16/5/2015 under section 161 of UP Jamindari Abolition and Land Reforms Act 1950. So he was allotted as an exchange to this site. But this itself was in dispute. So another person by name Umesh Pratap Singh, he is Misro, he is Singh, Umesh Pratap Singh. This man, he wrote to the RDO or subdivision magistrate that the exchange of the land was wrongly made. Ikkad dorkinది. Misra is residing in a particular house, but this Umesh Singh, he has made a representation to the sub-collector that the exchange itself was wrong. So they have conducted an inquiry through the Tehsildar and who submitted the report. Tehsildar submitted the report that the exchange was not correct. So therefore, on 16/11/2022, the subdivisional magistrate, they have cancelled the exchange order. And they have made an entry or mutation. They have made an entry in the revenue records, and later the house was demolished. When this man objected, they have registered a case against him also. So this is all the administration wanted to teach the lawyers a lesson. So this is what we can understand. So therefore, the matter came to the notice of the High Court by filing the so-called public interest petitions. Here, High Court does not want to interfere in the orders given by the SDM because they are as per law. The exchange might have been wrongly taken place. Therefore, revenue people, they have got the authority definitely to take into consideration and give an order. But the point is the haste in which they acted, the undue haste. So, without giving an opportunity, that too to an advocate who is staying in the house, they have gone there, bulldozed and demolished the houses. So, before making the order, the SDM did not give proper and adequate notice to the petitioner. This is more important. So, therefore, the orders or the demolition is held to be actually against the law. But anyway, the proceedings of the subdivisional magistrate should be conducted properly and re-enquiry should be conducted and a fresh order to be given. Till such time, status quo has to be maintained. And please remember, the court clearly stated that the district administration should not actually unnecessarily harass the petitioner and the other lawyers. In this connection, Honorable High Court of Allahabad, they have actually placed reliance on so many cases. But whatever it is, so all of you know, this is basically on the principles of justice, second principle of justice. So never act in a hasty manner. No doubt there will be so many circumstances where you have to teach the others a lesson, but when the time comes, then only you have to act that too in a proper way, in a procedural way. That revenue people definitely they know the procedure. Without following the procedure, if you do in a hasty manner, then things will be like this only. Now the orders of the subdivisional magistrate, they were stayed, is it not? So this is a very good lesson to the revenue people. At the same time, it will be a good guideline case to the young advocates. So please read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.